case briefs, and so much more. LSData's got what you're looking for.
In the 1948 case, Leckie v. Foote Lumber Company, the Louisiana Court of Appeal grappled with a situation involving a worker who was injured while performing required tasks, but not activities that directly benefited the employer. The plaintiff, who suffered a significant and permanent loss of a portion of his left hand, sought compensation for a work-related injury. While the defendants admitted to the plaintiff's employment and initially paid compensation, they later contested the claim, arguing the plaintiff wasn't trimming lumber for sale at the time of the injury and disputing the extent of the disability. The injury occurred on a Saturday afternoon, when the plaintiff and the defendant's manager were at the mill to prepare it for a weekend shutdown. The plaintiff was responsible for operating engines and being available to scale logs as they arrived. After the district court ruled in favor of the plaintiff, the case made its way to the Court of Appeals. Ultimately, the Court of Appeal affirmed the judgment with costs, finding that the defendant wasn't liable for the injury, as it didn't occur while the plaintiff was engaged in tasks benefiting the employer. However, as the plaintiff was engaged in his employer's business and overseeing engines at the time, he was still granted compensation for his injuries.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class